Meet Robert. He's applying for his first apartment, and like many first-time renters, he carries a quiet fear, what if his application is denied? What Robert doesn't know yet is that, as a prospective tenant in New Jersey, he has rights when applying for housing. First, he should know that landlords may not deny any application based on protected classes or a person's source of income. Also, questions about criminal history can only be asked after an offer to rent has been made, and even then, only recent and serious convictions may be considered. Knowing he has the right to request a pre-move-in inspection and that the landlord must disclose lead paint and flood zone information, Robert feels relief. Before he signs, Robert carefully reads the entire lease, making sure he understands his responsibilities as a tenant and that nothing essential is overlooked. Meet the Kwans. They've lived in this apartment for more than 10 years. Over time, the unit has fallen into disrepair. At times, the Kwans feel overwhelmed, unsure of what to do and where to turn for help, but they are not without options. As a tenant, after notifying the landlord of the repairs needed and giving the landlord reasonable time to make the repairs, they have the right to contact a building or health inspector, notify the landlord that they are making the repairs themselves and deducting the cost of the repairs from the rent, notify the landlord that they are paying rent into escrow until the repairs are made, or they may take the matter to court. Every tenant in New Jersey has the right to heat and hot water, proper plumbing, secure locks, and working smoke and carbon monoxide detectors. The Kwans decide to tell their landlord they will pay rent into escrow until the repairs are made. After 2 months of depositing the rent into a separate escrow account, the landlord arrives with a repair person. Landlords may not enter an apartment without permission and must provide at least 24 hours written notice. Entry must occur at a reasonable time of day unless there is a true emergency. Entering without permission is illegal. Meet Tina and Tiara. Tina works 3 jobs, yet still struggles to keep up with rent. She usually pays, but often a couple of weeks late. Her landlord tells her that when her lease ends in 3 months, she must move out. But in most cases, New Jersey's anti-eviction law requires a landlord to offer a new lease unless there is a legal cause to evict. And landlords cannot evict on their own. They cannot padlock doors, remove belongings, shut off utilities, or threaten a tenant. Only a court can order an eviction. To begin the process, a landlord must file a case in court. For non-payment of rent, advance notice may not be required, unless the housing is public or subsidized, in which case a 30-day notice applies. For other lease violations, such as habitual late payments, the landlord must first provide a notice to cease before filing an eviction complaint. Tina has the right to stay in her apartment during the court process. She will receive a summons and have the opportunity to appear before a judge. Only if the landlord prevails will the court issue a removal order, which is carried out by a court officer, typically no sooner than 3 days later. 2 months later, Tina receives a new lease with a significant rent increase. She learns that some municipalities have rent control ordinances. Even where there is no rent control, rent increases cannot be unconscionable. With guidance and support from local agencies, Tina is able to secure assistance and sign her new lease. Tina is relieved. Avoiding eviction protects her housing record for the future.